Ladies and gentlemen, dear friends, the cycle of ideas is returning online today in order to converse with you on a timely and highly critical topic, one that derives from a very important judgment issued by the German Federal Constitutional Court on May 5th, a week ago. You may ask, why is this of any concern to us? Why should we be holding a public debate in Greece on a judgment by a German court? The reason that it is interesting to us is the fact that it focuses on the economic governance of the entire Eurozone, and it tackles the major challenge of European integration in the midst of the pandemic, in the midst of the critical conditions and the impact of the pandemic on the European economy and all the economies of the member states. So this debate has not been organized simply because out of a type of professional vice or perversion because I like constitutional law, for example, but rather because this is a judgment of the utmost importance, and it focuses on the legal order in the Eurozone, on the efficacy of the European law, on the legal relationship between the EU and the constitutional laws of member states, and it also raises topics that are very pertinent to each domestic market. And it also focuses on the QE, which is the quantitative easing and a policy that has been implemented by the ECB for many years and by many member states, and it also tackles the pandemic emergency QE with respect to solidarity and the ability at some point to reach a mutualization of debt, to reach an understanding, a consensus on Eurobonds and the harmonization of sovereign debt. So we will be discussing all of that with two of the most important experts that we could have on this panel, and I would like to welcome and thank wholeheartedly the governor of the Bank of Greece, Professor Yannis Stournaras, who is a dear friend. I think it was a very positive omen when we organized this debate because the government today, the Greek government, announced that his mandate as governor of the Bank of Greece has been renewed for the next 6 years, which means that he will also be an active and major key player in the finances and economic of the Eurozone as a whole. As a friend who has gone through lots of experiences and the crucial 2012-2015 period, as well as the 2015 and 2019, equally though slightly differently critical period, I have seen Mr. Stournaras, Professor Stournaras, look at things that went beyond the sensitivity of citizens' well-being. And I would like to wish that he remains as strong, as efficient, and as wonderful in his role as governor for the second mandate in a row. And I would also like to welcome another colleague and dear friend. We have been together in the University of Thessaloniki for many years, a former president of the Court of Justice of the European Union. He has honored the Greek legal science by becoming elected and re-elected as president of the Supreme Court, this utmost court, the Court of Justice. He has been behind important judgments in the Court of Luxembourg, and these decisions had an impact that still creates paves the way for the economic integration of the European Union. And I would like to point out that there is a distinct link between his career and his decisions and what is taking place nowadays with the German Federal Court. I would like to start with what the judgment is all about, what are the legal issues arising, and what the challenge is for the Court of Justice of the European Union, for the institutional edifice of the European Union as a whole, why this is of interest, particularly to Greece, given that we have striven the best we can, we have toiled in order to be to leverage and at the same time function and serve as a laboratory for quantitative easing. So I think that experientially speaking, as well as financially speaking, Mr. Skouris is the pertinent person to discuss this judgment. Professor Stournaras will be looking at the financial aspect with respect to the Bank of Greece, with respect to the Eurozone, the monetary policies and economic policies implemented, as well as the new programs that have arisen as a result, direct result of the pandemic. Let us start with the intervention of Professor Skouris. Thank you, dear friend. I would also like to thank Yannis Stournaras for being re-elected as governor of the Bank of Greece. But I would also, since it is time to tackle this decision, I would also like to point out that the decision of May 5th is not something that has sprung out of nothing. It all falls back to the Maastricht Treaty that established the monetary union. And at the time, the Court of Justice, for the first time, decided that it should invoke its competence with respect to the legal and monetary issues throughout the Eurozone, which means that that treaty stipulates that all acts of institutions, European Union institutions, that are not covered by the competences conferred to the Union should not be binding and should not apply in Germany, because they have been issued, as we call it, ultra-virus, meaning beyond the competence, beyond the jurisdiction. This ultra-virus became a term that was repeatedly used by the court, and it was very often used as a threat in order to impede the EU Council decisions. And it is quite indicative that the court considers ultra-virus methodology as a given, despite the fact that 30 years after its institution, it has not been implemented, but only once by a constitutional court, and at a very marginal case that very few, even among the experts, are aware of. So this threat of the ultra-virus as a safeguard created in Germany several remarks and criticisms that became quite ironic. However, this is changing, and this look to the past was necessary because I wanted us to realize that the Court of Justice of the EU created a constitutional edifice in order, the German Federal Constitutional Court created a constitutional edifice that would allow it to exceed competences. And it had to overcome two obstacles and justify the reasons why the ECB should implement this program and at the same time review and also annul the program. And this was a course of action that the German Federal Constitutional Court wished to follow. And this is why I say that they acted ultra-virus. The German federal government and the Bundesbank have been criticized that they took their time and delayed in implementing measures and at looking at the principle of proportionality as it should be implemented by the ECB. The fact that they failed to do so led us to the conclusion that the program of the ECB was in fact an ultra-virus act, as this is defined by the European Union law. The next step, which was even more critical, had to do with the decision of the Court of Justice, the EU Court of Justice, with respect to the Vice case, whereas several citizens complained before the Constitutional Court, and the Constitutional Court had decided that it would not condemn as ultra-virus acts if it had not first consulted with the Court of Justice of the European Union. And this is why we had, back in 2012, the first preliminary request by which the Court of Justice of the EU would have to declare this text as a text that goes beyond the competences and jurisdiction of the ECB. The Court of Justice of the EU on 2018 looked into all the arguments of the German Federal Constitutional Court, delved deeper into the principle of proportionality, and came to the conclusion that this program is not an ultra-virus program. And based on that decision, the German Federal Constitutional Court didn't have any other way out, and it was impossible to ban the constitutional complaints brought before it, given the fact that the exclusive jurisdiction is something that applies to the Court of Justice of the European Union, and the Court of Justice of the European Union had stipulated quite clearly, ruled quite clearly, that the principle of proportionality had not been tampered with. And this led to a ban of a rejection of this decision. In order for the Federal Constitutional Court to be able to reject this decision, they brought forth a complaint whereby the Court of Justice undermines the principle of proportionality, that it draws arbitrary conclusions and acts in an ultra-virus way. And the Constitutional Court moved on to negative conclusions and deductions, framing itself in a way, given the fact that they based their ruling on the principle of proportionality that they had already claimed that the Court of Justice of the European Union went beyond by acting ultra-virus. And that entailed that the ECB and the Constitutional Court were given a 3-month deadline in order to alter their relationship and make sure that the principle of proportionality is well respected. So we could ask ourselves whether, given all that I have said, the conclusion is not a conclusion without substance. Now, if we look at the wording of the judgment and the justification, the rigid justification, we may say that this is no big deal because the ultra-virus acting of the ECB may be remedied if we review the principle of proportionality with respect to this program, purchase program, which would lead to controlled damages. However, in reality, we could say that what we're dealing with is just a justification, an excuse, but there is a very important damage made, and I think that we will see that clearly when we talk about the conclusions drawn and the implications of this decision. Thank you for placing this in a legal, judicial framework and as well as political framework. Now I would like to ask Professor Stournaras to take the floor. I want to set forth the following question. Transferring, or rather conveying, the picture depicted by Professor Skouris, the Constitutional Court, given all this background that Professor Skouris has explained, claims that the European Central Bank, the ECB, which is exclusively incumbent for the monetary policy mandate, and what we're looking into in greater detail is the monetary policy of member states, has already penetrated quite deep into the competence of member states by looking at the economic policy. Let's not forget that it is the European Union that has the sole coordination authority for economic policy, whereas monetary policy falls under the jurisdiction of the ECB, but the ECB seems to be exceeding that mandate, and this has an impact on interests, deposits, because savers do no longer have interest rates, positive interest rates. This has an impact on yields, on banking portfolio, on the financing terms of member states, that irrespective of economic and fiscal status quo of each member state are key players in the domestic market. And all this is something that the European Central Bank failed to look into by means of a dedicated study that would take into consideration the principle of proportionality and make sure that these programs do not exceed their impact on the monetary policy of domestic markets. What the court is saying, in simple words, in layman words, is that quantitative easing, which is a secondary market, as the governor, I'm guessing, will be explaining to us, is in fact moving beyond the secondary market boundaries, given that these securities will be purchased within the secondary market. This is something that has been going on for years. It has created a huge volume of market volume of 2 trillion. It has filled to the brim the portfolios of primary banks like Bundesbank. The main question is, could it be that the secondary market is a visual secondary market? And could this be a device that skirmishes satellite financing? So they're saying that it's not financing per se, but it's very, very close. So the main question, the key question is, a central banker, European Central Bank, how will it react? What will it do? What will happen from now? What is the implication, the repercussion on previous existing programs? It's very important to have an accurate understanding on these issues. So Yannis, the floor is yours. Thank you very much, first of all, for your kind words. Dear President and Professor Skouris, it is obvious that I will do my best in order to honor the trust bestowed upon me with the renewal of my term as governor of the Bank of Greece. And of course, I will do my best and I will undertake all endeavors in order to bring back financial stability in Greece. Legitimacy of security purchase programs, no matter which program we're talking about, let's focus right now on the PSPP, the Public Sector Purchase Program. This created a large deal of confusion. However, it was not the case in markets. Markets do not fear the implications of the public sector purchase program, and that is important. As you said, Professor Skouris, back in the beginning of creating this PSPP, the ECB acted ultra-virus, and the Constitutional Court claimed that this was an ultra-virus act and called upon Germany and the ECB to stop utilizing this program until it could ensure that this program was not disproportionate to the impacts of the instrument as it was foreseen for the member state markets. The Court of Justice of the EU in 2018 said that the PSPP is fully in line, fully compatible with EU law. So in this case, who has the say? Who is responsible and who is competent? The decisions issued by the German Federal Constitutional Court did give rise to confusion and uncertainty. I think that Professor Skouris was very clear with respect to the legal issues, and not being a legal expert myself, I will avoid going in that direction, but I will look at the sequelae on the economic and monetary policies of the European Union. First of all, I want to speak of the independence of the ECB and decision-making with respect to the PSPP back in 2015. There are many important reasons why the ECB and other central banks. Let us not forget that the ECB was established back in 1999, and we had studies and surveys in the 80s and the 90s that looked at the banking system, and they said that independent banks, such as Deutsche Bank, are the ones that yield better results. So an independent policy, banking policy, allowed banks, independent of political wills and political commitments, allowed banks to provide better yields and better benefit to their customers and to themselves. The ECB is independent, however, it is also accountable. The president, the governor of the ECB has to meet with the European Commission and the European institutions very frequently in order to justify the course of action of the ECB. As myself, as governor of the Bank of Greece, I am accountable to the Greek Parliament and the Greek people. And this entails that the ECB can freely decide upon how it will design and implement new programs or new objectives and instruments. With respect to the main objective of price stability, there has been a cascading effect of many actions and endeavors by the ECB, drizzling into the member state markets. And in the case of force majeure, and we could argue here that the pandemic is a case of force majeure, the ECB has the competence to play a more interventive role in order to ensure price stability, meaning that it disallows or allows certain instruments and practices to be implemented throughout the member state markets. There is, however, no single monetary policy for each separate individual member state. These monetary policies have to tackle the EU, the Eurozone as a whole. And this is why some decisions sometimes are perhaps less suitable to some states, member states, with respect to others. There is no fit-for-all solution. Let us not forget that the US Federal Reserve also will not take into consideration separate states like Texas or California, but rather the entire federal territory of the US. So could a domestic court, could a national court reject a policy, a monetary policy drafted, scheduled, designed and prepared for the entire Eurozone, what would be the repercussions if each national court decided to complain against decisions of an institution falling under the EU and fully accountable to the Court of Justice of the EU? I think that the repercussions are obvious. So I would like to look at January 2019 and the first launch of PSPP. At the time, we had a negative inflation and there was a dire threat of increasing inflation. And this created a threatening, a major challenge. We know that deflation, based on historical background, deflation or negative inflation or very low inflation is as bad as increased inflation, because deflation reduces investment cost, thus leading to financial recession, meaning that individuals with stable debts will see their debts rising, and this can lead to liquidations, settlements, and bankruptcies. So, let's not forget that we had the major depression that took place in the US in the previous century, the Great Depression, and which lasted until the end of World War II, was characterized by deflation. And unemployment rates had gone up to 11.5% at the time. And let's not forget that once again we see strong fragmentation indications within the banking sector and the banking market. And the different courses taken with respect to monetary policies added to this fragmentation. So the Eurozone at the beginning was in at the beginning of the crisis was faced with multiple challenges, and these challenges changed but did not were not eliminated by 2015. So within the Eurozone, fiscal interventions unfortunately did not have at the time the desired effect, which means that at the time the European Stability Mechanism was still taking its first steps. It had not been able to contribute to instability, and there were several negative sequelae that were envisaged, and that is why there was a decision made to move to such programs. We started with OMT, and I can remind everybody that this was this continued until early 2020, where we had the first turnaround of this situation. Governments in the Eurozone were faced with developments that robbed currency, the European currency, of strength, and economists were afraid when they saw that prices were falling, the stock market was suffering, and this is all something that has been recorded in minutes. Prior to the PSPP, there was a long-term public consultation in order to ensure that broader public and all institutions and organizations that were implicated or involved or interested in any way would be sufficiently informed. And during those consultations, very many negative potential sequelae had been pointed out. Members, higher officials of the ECB at the time, and I remember a Zurich conference in a few years back between IMF and ECB, that this could lead to a bubble in real estate prices. Vito Constancio, the then president of IMF, at an annual conference in Mannheim in 2015 in Germany, therefore, mentioned the risks to financial stability that could stem from higher leveraging and weighting of non-standard procedures and measures, and how this could impact redistribution of wealth. However, contrary to and going against these negative sequelae, they also pointed out that the programs and measures already taken were working towards ensuring stability. So there appeared to be no reason to interrupt this monetary policy, because all negative impacts could be countered by macro prudential measures. And there was no indication at the time that there would be an estimate, an excessive estimate, a bubble of any sort. And I would also like to say that the Federal Reserve, the Bank of England, the Bank of Japan, the Bank of Switzerland, the Bank of India, the Bank of China, they all reacted in similar ways to the financial framework of those times, even though their decisions were customized to each domestic market. As such, I do not feel that the Federal Constitutional Court of Germany has grounds to say that the ECB went beyond its competencies, exceeded its competence. I don't want to say more because I risk being less genteel. There are, however, many things that are related. We have seen that there have been dysfunctions, that there have been deficits with respect to the institutional implementation of monetary policies, and this has been aggravated grandly by the pandemic, and there are existing truthful and quite actual problems that need to be tackled, but we should not try to tackle them by falling back to nationalistic behaviors. Decisions and instruments set forth by the ECB can indeed help guide the monetary policy of the EU. The ECB should be able to continue to draft the monetary policy for the entirety of the Eurozone without trying to tackle in a fragmented way the fact that there is a fragmentation in bank. Aristotle, back in ancient Greece, said that currency depends on law. Law needs to be implemented if currency is to be credible and trustworthy. And this is precisely what the ECB is doing. They are trying to fulfill their mandate as per the treaty for the function of the European Union. And you asked what the ECB may do. I would like to mention some citations by our governor, Ms. Lagarde, who said, after a meeting of the Governing Council of the ECB, that both the ECB and other central banks should look beyond known and well-established instruments and try to utilize extraordinary and emergency measures in order to avoid a policy that grows rigid and has a negative impact on households. We need to ensure that the monetary policy is transmitted throughout the Eurozone. The president of ECB in the State of the Union meeting back in Friday said that the ECB will do, quote unquote, whatever is necessary, and that the ECB is undeterred, meaning is not going to back on fully implementing its mandate of monetary policy. And they also said that we should clarify that there should be no undue constraints with respect to the policy. Continuing with the quote, we are an independent institution, we are only accountable to the European Parliament, and this incites us, and this motivates us, and this drives us. And we will continue to do whatever is needed, whatever is necessary to deliver on that mandate. We are undeterred. I believe that we will come up with a solution, and I will be working in that direction, finding a solution so as to avoid consequences, so as to avoid a heavy impact, not just in monetary policy, but throughout the financial market. Thank you. Thank you, Governor, for this systemic and institutional response. I would like now to merge these two viewpoints, the legal and the financial viewpoint. I have lived through very difficult financial times as a minister, as a member of the Greek Parliament, and I know that the ECB has always done its best, what it had to do in order to protect stability within the Eurozone. The ECB does precisely what all major banking institutions of all major economies are doing. Fed, the Bank of England in the UK, and so on and so forth. However, unfortunately, the European Union still suffers from several signs of, let's call it, compulsive behavior. On one hand, we have monetary union, but we do not have an economic union. And this gives rise to friction, never-ending friction, with respect to the allocation and distribution of powers, because we have the European Central Bank, which is responsible for the unified, the single monetary policy of the EU, and on the other hand, we have sovereign banks that are responsible for the economic policy within their respective markets. And when viewed in this context, the context of the decision and this entire case between the Federal Constitutional Court and the Court of Justice, this all brings back to mind the Deauville Declaration, the Merkel-Sarkozy at the time declaration, which stated quite simply that we cannot impose single interest rates throughout all domestic markets. Interest rates should abide by the standards and settings of each individual economy, national economy. And this is something reiterated, revisited by the court based on the findings at the time of the Court of Justice. So the decision says, the judgment says, yes, the countries, the member states have an economic policy, the ECB has a monetary policy, and you are imposing, as an ECB, you're imposing things to us without asking us. And the Federal Constitutional Court said that you did not explain to what extent the impact will affect the economic policy of each member state. And that means that it was an ultra-virus act, because the ECB failed to review in depth a program. And this program, the fact that this was done ultra-virus was what brought it before the Court of Justice of the EU. It violated, it went against a main principle of the EU, the principle of proportionality, and a marginal review showing that there is no manifest violation of the letter of the law by the ECB, led the Court of Justice to say that it was an ultra-virus act when the Federal Constitutional Court failed to look into the best way to implement the EU policy at national level. So now there is pressure by the Bundesbank and by the Bundesbank, which holds more than 60% of the capital, to come up with an exit policy from the QE in broader terms, from the quantitative easing. It needs to start shedding off the surplus burden of bad bonds. And according to the Court of Justice, the decision actually says that you were right with respect to what was taking place in 2015, but now we're at 2020 and things have changed, and governments are issuing bonds in view of having the ECB purchase these bonds later on. So there is no blackout period, there is no clear distinction and separation of the primary and secondary bond market. You have purchased negative yield bonds, you hold on to them until their maturity, which means that you have created a system which in fact is a primary market. So explain yourselves now, 5 years down the line. This, however, does not give rise to immediate and practical results. It all boils down to how Bundesbank will reply and will position itself within the European system of central banks. It's not just about whether it is the EU law that supersedes the German use. The German Constitutional Court agrees that the EU law supersedes, has its supremacy, and should be implemented. Given that the member states are masters of the treaties, in marginal and extraordinary cases and circumstances, they need to review the principle of conferral of powers. And what the court is saying is that in this case, we're talking about an ultra-virus act because there was no implementation of the principle of proportionality between the monetary ECB policy and the national economic policy. And this needs to intensify. So they have created a trap. And herein lies my personal question to Professor Skouris, dear friend and colleague. How should and how do you think that the European Commission will react, and the Council, and the European Council as well? Do you think that there is a legal procedure that will be enacted, for example, against some legal proceedings brought forth against Germany? How could that happen, and what would it entail? Also, moreover, the Court of Justice of the European Union, based on your thorough understanding of law, the EU law, will take into consideration the objections of the German Federal Constitutional Court, thus just providing a sequence of repetitive complaints. And towards Mr. Stournaras, given that European integration and all procedures within the European integration are constantly re-evaluated and renegotiated, do you think that the position of the German government is reinforced with this procedure, or is it weakened? Could it be that the German government, the federal government, based on this decision of the Federal Constitutional Court, will come to decide upon a monetary and economic policy that will salvage the QE, the PSPP, PPP, and so on and so forth, but will create a new framework through the pandemic emergency purchase program? And let's look at this from the perspective of the ESM, European Stability Mechanism. Could this have an impact on the European Development and European Investment Bank which is the primary player responsible and competent for support and financing towards SMEs, given that what they're saying is as follows, that although the Court of Justice says that they have no grounds, that what they're saying is unsustainable, could it be that there will be some kind of solidarity between central banks and everyone will share the burden of this 2.5 trillion euro, which is further stressed by debts currently building up due to the pandemic? What will happen? Will the ECB be able to raise the burden of Spain, of Germany, and so on and so forth? And these are all new dimensions, novel dimensions. This is a new mine that has been introduced in the very foundation of the monetary standing of the Eurozone. And we need to see if we can disable this mine, if we can disable this ticking mechanism. So I would like to ask once again, Professor Skouris, to take the floor and provide the legal aspect. I'm not sure if Mrs. Skouris can hear us. Perhaps we should move on to the governor of the Bank of Greece first. Governor, please take the floor until we have a connection with, re-established the connection with Professor Skouris. Well, first of all, is there a risk of inflation within the Eurozone today? That's a risk which is set forth by the German government, but there is no such risk. Right now we are below the target. The objective was below or close to 2%, and now we're close to 1%, which means we are far below the desired target. And all estimates, all experts foresee that we will continue to stick close to this 1%, notwithstanding the impact of the pandemic on the markets of commodities, oil, raw materials. International demand has dropped below international supply. So there's no risk for inflation. Number two, as you well know, Greece is not part of the PSPP, but it is part of the PEPP, the Pandemic Emergency Purchase Program, and there's no risk sharing within the PSPP, which means that each country will buy government bonds of its own country. So Bundesbank, for example, only has now government bonds of Germany. German government bonds and German sovereign bonds. They cannot buy Greek government bonds, which means that each national bank is responsible for purchasing some of the bonds of its own country. So this overrides the second argument of the German Federal Constitutional Court. And the bonds that have been purchased, and this links us to the exit strategy that you mentioned. Bonds purchased have been resold at higher prices, which means that banks have come out of such deals as winners with profit. So let's not forget that loss is intertwined with the economic policy of each and every country, meaning that loss and damages at a national domestic market level does not go hand in hand with the with international market. So if there is a market, for example, in Latin America that's not doing well, let's think about some countries that have a debt, that have had a sovereign debt for more than 30 years, and nothing has gone wrong. By printing out money, they create revenues for the state, and thus counter the minefield of other problems at a financial level. In Japan, in South Africa, there are laws, golden rules, that stipulate that the profits of national banks are not directed to the citizens, but to the state, with the exception of a percentage. And then interest rates. There is a slight misunderstanding with respect to interest rates. When the actual interest rates and not the nominal interest rates are the ones that are offered to the end customer and consumer. The nominal interest rates in the past in Germany have been negative 10 times more than they are currently, which means that there is no damage brought upon the German citizen and consumer, the German household or the Italian household. So this is no longer a valid argument, especially now. And you asked, could it be reinforcing the position of the German government? As far as I'm concerned, President, I think Germany will try to come up with a solution, because this decision, this ruling by the German court, if taken to extremes, it will lead major problems to Germany itself. So I think that Germany will try to do its best in order to come up with a politically correct decision. A legal consultant to the Bank of Greece told me that some citizen will come forth, go to the court and present before the court exactly what I've said so far. There have been hundreds of studies and surveys that have corroborated that the principle of proportionality has not been violated by the ECB. And all that needs to be done is for somebody to bring this forth as an eyewitness before the court. In the Financial Times today, there's an article where the reporter says that this ruling, this judgment, could help lead to a new Europe whereby the central institutions have a greater say, for example, in fiscal policies, which is not the case nowadays. There is the theory of macroeconomic balance and symmetry. Here we have +8, +9 cases that nobody seems to be referring to. So could it be that now is the time to have a more substantial Eurozone? I'm not saying federal-like Eurozone, of course not. I'd never dream of saying that. But have stronger institutions looking into both countries with surpluses and countries with deficits, and not just countries with deficits. So there's the contrary viewpoint saying that this judgment, this ruling, could potentially help Germans realize that this is a dead end. We cannot have a monetary policy without some elements, some part of a fiscal policy. So we need to move in that direction. For those who disagree, for those who wish to turn a blind eye to this approach, to this perspective, and try to persist in more individualized perspectives, I think this is something that could undermine the whole edifice of the EU. I know that I have been often criticized, but I fervently believe that we need to expand competencies in order to ensure that European integration is facilitated and accelerated. I fully endorse what you're saying, and I hope that your optimism will ring true. I know, however, it's very difficult to move towards a single fiscal policy. For example, when we have such a low EU budget, when the union budget is so small, less than 2.5% of the EU GDP, and because of the pandemic, I think that all these measures, all these programs that are introduced in the market by the EU are no more than 1/7 of the GDP of most member states, as compared to the programs put forth by the German government. However, this entire topic that we are discussing could be, it could be that we're discussing it now because we are so close to German elections, whereby Christian Democrats and conservatives are trying to return to higher standings. I remember Cherie Blair, who is not very popular in Greece. However, he went to the Constitutional Court in Karlsruhe many times in order to help the Greek state and facilitate disbursement of installments, of financing installments towards the Greek state. And these installment payments were actually put forth and created for memorandum states. Let's not forget that before the PSP, we had the S&P, the Securities Markets Program. And this was something that everybody was talking about because we wanted to reinforce our own budget in order to move out of the financial crisis. So I fully endorse what you've said, but I would also like to say that I have slight reservations because of risks that are still in place. We can now move on to Professor Skouris, who we were unable to listen to beforehand for technical reasons, and we will benefit from his large experience. Unfortunately, I was unable to follow your entire intervention, so I'll just have to reply to what I have heard, and since that's the only way for me to actually make my own intervention. Yes, we need to look at the long-term aspect. However, I feel that you are being optimistic, but slightly excessively so, as far as I'm concerned, because right here, we're not dealing with a judgment that could be dubbed an unfortunate moment of the Constitutional Court, or a judgment that emanated from the Second Senate of the court. For those of you not familiar with the proceedings, the rapporteur has to step outside the court in order before the decision is made. I feel that there's a gradual development behind the scenes that led to this decision, the judgment by the Constitutional Court. And this decision, this judgment, as far as I'm concerned, is not as appealing to Germany as was the OMT judgment, the outright monetary transactions judgment, because at the time, the Constitutional Court accepted and approved, based on the Court of Justice of the European Union ruling, this program. Here, it will be a lot more difficult to reach a standing of ultravirus in this case. However, I fear that the parties involved felt that they would be able to engage greater parts of the program. Let's not forget that the complainants themselves, should the court follow a different trajectory than that instigated and set forth by the Court of Justice, they would do so in order to ensure or to prove, to demonstrate that they did instead review the principles proportionality, but that's something that the Court of Justice of the European Union should be doing. If the Constitutional Court actually does that, it will be a victory for them, because this way they will be closer to taking control of the ECB by means of the German Federal Court and not by means or going through the EU Court of Justice. And this is the main difference between the proceedings of the German Federal Constitutional Court and the Court of Luxembourg, because how can we have an optimal result achieved with respect to the labor law in European Union, for example, if one court claims that this positioning is inadmissible, unacceptable, that it is a manifest virus or exceeding of power. So in a few words, completely arbitrary. I remember that I was often asked what I think of the ultravirus case law, and I always responded very honestly and quite naively in hindsight. And when I said that I'm not very fond of this case law, that a court should tell another court that I will go through an ultravirus review because you're not doing it, it felt petty. And I never thought that there would ever be an institution, a court, that would go against the Court of Luxembourg and claim that their decisions are arbitrary in favor of the European Union and against member states. So this is a very heavy complaint that is completely beyond me. But at this point, we need to realize that taking a step back, if the ECB takes a step back, this should be reviewed and evaluated also on the basis of what needs to come next. Should the ECB plan policies based on the input of each and every court of the 27 member states? Should it be subjected, even at a minimal degree, subjected to the control of the courts of member states? Going back to the Maastricht Treaty, there's this very difficult and sensitive differentiation between monetary and economic policy. And yes, member states need to have a greater say in their own economic policy. However, it's not the member states themselves that are claiming a greater transparency, but rather a constitutional court of a single member state. So it's not something that brings the member states against the EU, but rather it's something that brings one member state's constitutional court against the ECB. So we need to look at the judicial and legal instruments that the ECB should enact in order to step out of this conundrum. Let us not forget that currently we have a German president of the Commission, and she said that as of day one, we've started investigating this subject. I'm unawares of details. However, we know for sure that we cannot perpetuate this obstacle, this difficulty of defining what is ultravirus, acting in ultravirus, and what is not, because otherwise we will have great obstacles. It is almost self-evident that Ms. Lagarde spoke of the need to not bring down the edifice of the ECB. For anyone listening to us, I would like to point out, or rather to make a rhetoric question. What is the interest of a German constitutional court? And what is the rationale behind accusing the ECB of going beyond what it should be doing, acting in ultravirus? The German Federal Constitutional Court said that what they did was a common constitutional practice of all member states. It dates back to the Acte de Gouvernement, it dates back to a multifaceted financial subjects and other complicated technical subjects, whereby we see that there is control exercised by judges, and this control needs to be marked. The memorandum could not be controlled, could not be reviewed in substance, in depth, by any single judge, because there was a multitude of parameters that needed to be taken into consideration. National policy, monetary policy, European policy, foreign policy, EU foreign policy. So this should not fall under the competence of a single country's court, of the court, for example, in Karlsruhe, the Constitutional Court. And if we have one constitutional court stepping forth, what happens to the other 26 constitutional courts in the European Union? Because they speak of a breach of the constitutional identity, but the constitutional identity should have its own idiosyncrasy. Anything that pertains to the power of parliaments and constitutions may be nationalized, national in nature, but there are many common elements, there are many common reference points. And I will draw your attention to Article 7 of our own Greek Constitution. So, addressing the Governing Council of the ECB and of the Bundesbank, if there was a letter sent to the German government followed by a justified opinion, could it be that we would come up with a new justification? Because the German Federal Constitutional Court says that I am waiting for novel justification on behalf of the ECB. And if that doesn't come to me, then there will be an intensification of the tension in between the two bodies. And the Constitutional Court will have to define why they speak of a breach of the EU primary law. And so this is something that could have many repercussions. So the major players, the Constitutional Court and the German government and the ECB, should reconsider all that is going on, because crucial topics need to be addressed at an intergovernmental level and also at an institutional level, because the European Council cannot be indifferent, given that they are the ultimate political institution competent on the matter. I would also like to add, Mr. President, that we should not disregard, given that there are other proceedings that are already underway, that there could be discussion of interim measures on behalf of the ECB. This is a possibility. Let's hope that we don't get to that point. I'm just saying that it's a possibility, because somebody may ask what's going to happen in the 3 coming months. The German court has allowed for a 3-month time frame, and if the ECB does not help the German Bundesbank and the German federal government, then there may be a new problem. And let me also remind us all that the ECB, according to the literature, had a most unpleasant experience that it was called as an expert at the German Constitutional Court, and they were bombarded by questions and insults or hardcore questions. The second time, the ECB did not send a representative at the German Federal Constitutional Court. And I think this is a precursor that they got the message the first time and they will change their behavior accordingly. Allow me to point out that when the institutional edifice of the European Union targets the German Federal Constitutional Court, then the German government, the German parliament are under the obligation for their own institutional reasons to defend their court. So there is a very difficult conundrum here that requires vision and long-term perspective. And that's why I mentioned the European Council, because, okay, we can have lots of legal arguments, but the entire endeavor of European integration is a historical challenge, a historical bet that needs to be won, that needs to be nailed by the leaders of a European Union that is under great duress. We all need to help, said Professor Skouris. Governor, do you have something to add before we conclude our discussion? In the Governing Council of the ECB, we have not yet come to a decision as to our response. I mentioned what Ms. Lagarde has said. Personally, I feel that we should try to not aggravate the situation, but keep our cool. We have many documents, lots of proof that is already part of the literature we have on the site of the ECB, and this needs to be promoted in a way that we not go against the Constitutional Court. We do not want to go against them, but we want everybody to know why we are working in this or that modus operandi in Italy or Germany or what have you. So we're trying to balance out our own standing. Some people claim me that I'm overly optimistic. Mr. Skouris says that I'm perfectly happy to see optimism in you. There is a saying that when it comes to analysis, pessimists are usually right, but optimists are usually the ones who own the world. So I think we will be able to come up with a golden medium, a golden rule that will allow us to move forward. In the past, we've come up with even more difficult situations, like Mr. Cherie Blair that you mentioned before is a very well-known legal expert, but he was extremely saddened by what had happened at the time. I think that it's true, there is danger to the entire European edifice. And perhaps this discussion that we've had here today will allow you to convey some new ideas, both to the ECB and the Governing Council and to the European Parliament. I think that we have made this first multifaceted, multidimensional approach to the topic. I would like to thank you wholeheartedly. Thanks to your knowledge and to your expertise, you have contributed largely to this meaningful discussion, and I would like to wish you the best for your institutional objectives. And of course, with respect to the historical challenge of European integration. Thank you very much. Good afternoon.